be leading the webinar today and Q&A session. We also have Eric Kong, who is the CEO and Virtual Chief Information Officer for Consilien. He'll also be with us, and Nancy Schwartz, who is the CEO of Symmetry and Associates and one of our premier partners at Consilien. So before we get started, I just wanted to give Nancy just a moment to talk a little bit about Symmetry, and then we'll tell you a little bit about Concilium, and we'll jump right into the presentation.
Perfect. Thanks, Krista. Good morning, everybody. My name is Nancy Schwartz. I'm the managing partner with Symmetry. We are technology sourcing consultants. So we work hard to connect our clients with the best service providers in the areas of voice, data, cloud, and managed services. So we're really excited to be working with Concilium. They've been a long-time trusted advisor of ours for all of our security needs, and we're really looking forward to getting their insight and advice regarding the new CCPA Act.
Great. Thanks, Nancy.
Thank you.
Let me tell you a little bit about Concilium. So Concilium was established in 2001. When we started, we were primarily consulting, bringing enterprise-grade best practices and security management methodology down market to the small and mid-size organizations. Eventually, we evolved in becoming a managed services provider. So once we were doing all the consulting, our customers said, hey, why don't you manage the infrastructure for us? So we have a deep experience in backup disaster recovery, proactive IT management. And we also have our own, cloud infrastructure. And now we have evolved, matured into a security services provider and a managed security services provider. And we're able to provide our customers with end-to-end cybersecurity, managed cybersecurity, compliance, and consulting. So that's a little bit about us, but we're here about the California Consumer Privacy Act. So this is what our agenda is. Today we're going to talk about what it is, when it went into effect, and who has to comply with it, the types of data, CCPA and consumer rights, that's very important. Of course, the penalties for noncompliance. This is another very important aspect of this law. Vendor management, CCPA action items. So we want you to leave with things that you can do today to start to get ready for CCPA. And then we'll also have a Q&A session at the end, and you'll be able to ask James all your questions, and he will do his very best to give you the correct answer. So without further ado, I'm going to give James control of the session, and we're going to move on. James?
Great. Thank you, Krista. Hang on. Here we go. Great. So first of all, good morning, everyone. Thanks for joining us. The most common question, of course, that I get is, what is the California Consumer Privacy Act, or you'll always hear it referred to as CCPA. So CCPA is the most comprehensive privacy law in the country. It's targeted at companies that collect and or sell personal information. Basically, it's fundamentally designed to give Californians more control over their own data. In the past, if you went to a company and said, give me my data, basically they can make you pay for it or simply tell you no. Now it is a legal right. I don't know if you've heard of GDPR in the past, which came about a year and a half ago. CCPA, think of it this way. It's sort of the Californian or the United States version of GDPR. So when did it go into effect? The law has really only just begun. The CCPA bill was passed by the California State Legislature and signed into law by the governor in June of 2018. There have been some amendments since that time in September and October. However, it really just became effective January 1st, so literally last month. However, the California Attorney General's enforcement of the law will only begin July 20th. So now, of course, people say, well, how does the enforcement work? Well, the truth of the matter is no one really knows how it's going to work. I mean, a lot of people are familiar with GDPR. They've been going after some of the big companies, and there have been some huge fines associated with it, but nobody really knows at this point in time exactly how they're going to enforce it, other than, of course, we already know what the fines are going to be, and we're going to run through that momentarily. So, who's affected by this? CCPA applies to any business, including any for-profit entity that collects personal information of California residents, and it satisfies at least one of the following thresholds. So the gross revenues have to be in excess of $25 million. You buys or sells personal information of 50,000 or more consumers or households, earns more than half of its annual revenue from selling consumers' personal information. So as you can imagine, this represents a huge percentage of businesses. So now, what types of data fall into CCPA? The definition of personal data, it's a little bit complicated, but basically CCPA defines personal information as information that identifies, relates to, describes, is reasonably capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. So of course, you know, what does that really mean? The reality is any identifier, real name, alias, postal address, an online identifier, an IP address, an email address, social security, driver's license, biometric information, geolocation data, records of personal property, professional or employment-related information, educational information, and the list goes on and on and on. Pretty much absolutely everything, okay? The one thing it does not consider to be publicly available information as personal is basically publicly, so how do I phrase this the best way? Publicly available information means information that's lawfully made available from federal, state, or local records, regardless of whether the data is used for the purpose that's compatible for which the data was made publicly available. So basically, every single thing is personal data unless it's publicly available and lawfully available. Again, they don't go into too many specifics in the law. They keep it pretty open-ended. For lack of a better word or lack of a better thought, just assume absolutely everything is included. Okay, now, for the CCPA and consumer rights, the different items that are involved are these four right here. Basically, it's the right to access information, or what's commonly known as the right to know. So consumers in California will be able to know basically the what, the who, and the why surrounding their personal information. Specifically, they can request the following, which must be provided in a digestible format. Again, what is digestible? It's open to interpretation. Basically, which categories of information were collected and sold? From whom was this information collected? With whom was it shared? To whom was it sold? Why was it collected? In addition, there's the right to deletion. So consumers can request that a business delete all of their personal information held by both the business and, by extension, their business's service providers. And we'll be talking about that a little bit later on. Exactly what does that mean? It gives consumers the right to opt out. So consumers in California will be able to direct the company to not sell their personal information to third parties. However, the definition of sell in the bill is a little bit broader than simply monetary exchange. As required by the law, businesses have to provide a do not sell information link on their websites or their mobile apps. Again, in the past, this never existed. Businesses have 45 days to provide specifics about the information collected when a consumer makes a request for this information. The businesses have to give users at least 2 different ways of requesting the information the business has disclosed within the past 12 months. So again, it's putting the onus on the business to provide the consumer with everything that they could possibly need to do these things, to opt out and to get all their information. Okay? Page down, next slide. All right, here we go. Penalties. There are massive penalties for non-compliance. Again, these are the types of questions that have been asked of me is, well, you know, if I don't do this, what's the big deal? Okay? So these here are some of the penalties that are associated with the law. So basically, the following sanctions and remedies can be imposed a fine of up to $7,500 for each intentional violation and $25 for each unintentional violation. So a business is not liable if it cures any noncompliance within 30 days. So basically, they have a month that they're not liable. This is basically after being notified by the regulators of the alleged noncompliance. However, there are caveats to that. Some types of noncompliance or a data breach may not be capable of a cure. This $7,500 and $25 is inconsequential. The companies that become victims of data theft or other data security breaches can be ordered in a civil class action lawsuit to pay statutory damages between $100 and $750 per resident and incident, or the actual damages, whichever is greater, and any other relief a court deems proper. So basically, what does this all mean? Well, should there be a data breach of, let's say, 100,000 Californian residents, the fine can be in excess of $75 million. So as you can imagine, one breach and the company can go under. So the penalties are absolutely gargantuan. Okay? For vendor management, so one of the things you have to understand is you have to be sure to update your vendor data processing, addendums, and other third-party contracts to address the CCPA obligations. You have to create a process for reviewing your current and your future contracts by negotiating the necessary CCPA amendments. So when it comes to vendor management, it can get really, really tricky because the CCPA applies to entities called businesses, as we described before what that was, also service providers and third parties, each of which is defined and treated differently. So a business, as I mentioned before, is gross revenue of 25 million, sells personal information of over 50,000 consumers, and so on. But a service provider is somewhat different. So CCPA defines a service provider as a for-profit company for which both the following conditions are true. It has a contractual relationship with a business to process consumer personal information for a specific purpose, and the contract prohibits the service provider from processing or using data in ways not outlined within the contract. So basically, in other words, there are specific lines drawn around what a service provider can and can't do with consumer personal information received from a business. Service providers can't share or use the personal information unless they're fulfilling their contractual obligations. And a third party, so a CCPA defines a third party. In the context of CCPA, a third party is defined as a company that are not businesses or service providers. So they're sort of like types of entities that don't collect personal information directly from consumers, including but not limited to things like advertising networks, internet service providers, data analytics, government entities, and so on and so forth. This stuff is pretty complex. It's best to speak to legal counsel, basically to figure out and outline exactly where your different vendors rank and the types of contracts you should have between them. Okay? So now, of course, the next question that would come along are, well, what do I do? What are the next steps? So basically, the steps to comply are basically listed here, and there are more. So it's basically knowing your obligation to the CCPA. You really need to understand exactly what you have. You have to map your consumer data, okay? You have to update privacy policies. There are homepage privacy links you have to put on your website, mobile apps. You need to develop processes for handling your consumer requests. You have to implement system changes. You have to train employees. You have to strengthen your data security. That's, of course, a huge one. It's listed as just an action item, but it's huge. There are assessments that need to be performed, all different types of assessments to understand basically what type of data do you have in your environment. Very, very important, because based on that data determines the sort of things that you need to do. You have to update your data inventory. Basically, where is your data located? What type of data is it? You have to update all of your privacy policies, all of your notices. You have to review your definition of what is sale. Are you actually selling information? What does it mean? You have to understand the different business units within the organization. How is it they're handling information? How are they how does a data subject access requests? How does someone basically say, hey, I want you to delete my data? How long does it take? So the list, as you can imagine, goes on and on and on. There are a lot of things. The items that we listed here are the largest ones, the biggest ones, but there are a lot of things to consider when it comes to CCPA. So with that being said, I've basically threw a lot of information at everyone. I rattled through a lot of things. Undoubtedly, there are questions. So now's the time. I will answer what I can. Bear in mind, I'm not legal counsel. I'm not a lawyer, but obviously I'm pretty familiar with CCPA and how it works, especially as it pertains to security, privacy, that sort of thing. So if you have any questions, please fire away.
Yeah,
Anyone?
everyone, thank you, James. I believe that everyone is on mute. So I am going to unmute you, and you can mute yourself again. If you have,
Hopefully.
yeah, hopefully. If you have a question, this is pretty informal. If you have a question, just jump on in with your question. And again, everyone is going to get a copy of the deck with the action items so you can look over it a little bit more carefully.
James, this is Eric. I'm watching moderating the chat, and there's a question being posted into the chat. And the question asked that I'm not located in California. The CCPA applies to me.
Sure. That's a great question. Again, it's one of the common questions that people ask. So just because your business is not located in California does not mean you're off the hook. Doing business in California could mean that it applies to any business that collects or sells personal information of Californian residents. In addition, the California Revenue and Taxation Code, they state that an out-of-state company is doing business in California if it, quote unquote, actively engages in any transaction for the purpose of financial gain or profit. So long story short, you're not exempt. You absolutely must comply.
That's a good question. Anyone else? This is your opportunity. I think there's more in the chat here. Let's see. Thank you.
Thought it would be a tougher crowd.
Yeah.
Ready for the questions.
Well, I'll pipe up for everybody else, and I'll throw a couple of questions at you, and then items that we have spoken to with other clients. Here we go. Here's some of that is coming in. One of them is like, do we need to delete all information about a person if they request it? And I believe you started covering that during your primary presentation. Sure.
So basically, the new privacy law has an extensive definition of personal information, which will need to be disclosed to consumers if it's been collected. So again, as I mentioned, I rattled off on all the different things that are included. However, the exceptions to the California Consumers' Rights to Delete, there are some exceptions to the rule. So for example, if there are certain categories like legal compliance. So if you need the data to comply with a legal obligation, you don't need to delete it. There are things along the lines of free speech. There are certain security types of security data. So, for example, to detect security incidents, protect against malicious, deceptive, fraudulent, or illegal activity, things along those lines. So there are certain types of categories. In general, the answer is yes. But if this data is classified under security, legal compliance, research, for example, in the public interest, free speech, things along those lines, that information does not be deleted. It does not need to be deleted. But again, as a general rule, assume the answer is yes. Again, for more information, you should speak to the legal counsel.
And it looks like we have another question. It looks like if Concilium can help us with CCPA. Yes, we can. I'm going to talk about that at the end. Specifically what we can do to help you with CCPA. And another question, James, my company is business to business, so do I have to worry about CCPA?
Again, that's a really, really popular question. So there's no general B2B exception under the CCPA. However, many businesses have been concerned about how to handle personal information of business contacts. So that is the personal information about individuals who are not acting as consumers in the general sense, but are engaging with a business to carry out certain communications or transactions with the business. So as with all recent privacy regulations, there's gray area around this. There's a lot of gray area. So basically, communications and transactions that, and this is straight from CCPA, is communications and transactions that occur solely within the context of the business conducting due diligence regarding or providing or receiving a product or service to or from are exempt from the CCPA. Again, it's a lot of legalese. There's a 1-year exception. So to bring it down to earth, B2B emails and other communications seem to be fine for now. That said, there are no B2B exceptions for the CCPA's requirements around allowing individuals to request their information not to be sold, ensuring individuals who opt out aren't discriminated against, promptly informing individuals of a data breach. So basically, if someone tells you that CCPA doesn't impact B2B, they're mistaken. They really are.
Here's another very good question. It actually speaks, and the question is Concilium as a vendor of ours in compliance with the law of CCPA? That's a very good question. Also, I think it directly applies to your vendors that are not specifically under the auspice of the CCPA. And Jim, can you speak to that?
Well, sure. I mean, firstly, the first question you have to ask is if you go to the initial definition of what is classified as a business under CCPA, or basically who does it apply to, okay? So does the company have an annual gross revenues in excess of $25 million? Does it buy or sell personal information of 50,000 or more consumers or households? Or does it earn more than half its annual revenue from selling consumers' personal information? That's the first question you have to answer. So if the answer to that is no, which is the case for Consilien at this point in time, you do not need to comply with CCPA. So that's the first part. Now, if the next question is, does Consilien comply to CCPA? Again, it's more complex because Consilien has got all of the proper security controls in place to adhere. Basically, Consilien follows all of the security best practices, so it adhere to it. Of course, Consilien doesn't have right now the necessary privacy links and that sort of thing because it's not the business that utilizes this, dealing with consumers. So it's kind of it's a little bit of a bizarre question to ask, that Consilien can't necessarily do all the things necessary because you're not collecting any types of consumer information, okay? So again, I hope that answers the question. It's a little bit difficult to answer because it's not the type of business that would need to comply with this law. Make sense?
Yeah.
Yes.
Thank you.
So if Andrew, if you have a follow-up question of that, by all means, ask us and type it out there or unmute. Here's another one, another question that came in. I've heard that CCPA exemptions exist for my company because we have to comply with HIPAA. Is this true? Okay.
So the question of HIPAA and another type of compliance called GLBA, which is for banks, there's an exclusion to CCPA. It comes up very often. Namely, CCPA exempts all PHI, or what's called protected health information, subject to HIPAA. It also exempts patient information maintained by these what's called covered entities that maintains patient information in the same manner as PHI. So healthcare entities and businesses in the health sector should exercise caution. They should not rely too heavily on the HIPAA laws related exceptions as a complete pass to avoid complying with CCPA. So the reason being is this. So the companies subject to HIPAA, they have to carefully analyze what patient information they maintain as what's called PHI and what patient information they maintain outside of HIPAA. So companies, they likely create, maintain, or process personal information that falls outside these exemptions. So as an example, personal information collected through websites, health apps, health portals, or other digital technology, or personal information processed by, non-healthcare components of HIPAA, for example, for nonprofits, personal information collected through conferences, fundraisers. All of that information has to be covered under CCPA. So again, the most prudent course would be to assume that the HIPAA exemption covers only PHI and the patient information. and they have to design privacy policies and practices accordingly. Again, people see this exemption and they automatically make the assumption. So yes, the PHI information under HIPAA is exempted, but all the other information which they undoubtedly collect would not be as part of this exemption, and they'd have to have processes in place for this, all the other data, the non-PHI data. Any other questions?
There's one more about nonprofits. Do nonprofits need to comply with CCPA?
Well, again, if we go right to the definition of it's funny, I was trying to bring up the slide, which I can't do right now.
Your control, James.
That's all right. That's all right. So basically, CCPA applies to any business, including any for-profit entity that collects personal information and satisfies the rest. So that's the first thing. It applies to any business, including any for-profit. So the answer would be no.
Okay. All right.
All right. So one item I'd like to supplement, and maybe I can provide a couple points that James can speak to a little bit more. And one of the questions we get asked a lot when we speak to our clients and potential clients in regards to CCPA is very often they come in and ask and say, okay, well, we know we have to comply to CCPA, and what is the roadmap look like? What do we need to do to make sure we comply besides just posting the required notices on websites? And that's something that if I could get James to talk a little bit about, some of the areas you need to, as an organization, what you need to deal with.
Sure. Yeah, absolutely. So first of all, I mean, you've already kind of done step one, is basically know your obligation to the CCPA. So understand, are you classified as a business or a business entity? If you fall, and again, most companies will fall under this category. The next thing you really need to do is you have to perform an assessment of your environment. You have to understand, where are the gaps in your environment, okay? Where do you need to work on? You have to do something called mapping of your consumer data. So again, you have to understand, where does all of your data live? Companies think they know where all the data lives. The truth is they don't. What happens is you have multiple business units. They all take in data from different places, from marketing, from loyalty programs, from email campaigns, and the data is scattered throughout the organization. So you need to understand how does it all come in? How does it all flow? Where is it all stored? Things along those lines. It's a large undertaking. There has to be an update to all the privacy disclosures. So there's a bunch of rules of how to update all privacy disclosures on your website and your mobile apps, things like that. To add things like opt-out pages, things along those lines have to be added. Where are you, what are you doing with this personal information? Who are you selling it to? What are the purposes of it? Things along those lines. Okay. As I mentioned before, you have to create the homepage privacy link. You need to have that. There has to be a process for handling consumer requests. So when a consumer request comes in, number one, how is it coming in? You have to have at least two methods by which to accept these requests. And when they come in, who's getting this request? How are you handling this request? When somebody says, delete all my data, are you sure you've deleted all their data? Because their data might be in 10 locations around the organization. And if you miss just one, you're non-compliant. You have to identify and implement system changes. So you've got to, once you understand the flow of how things should work, you've got to implement these things such that when someone makes a request, again, it depends on your organization how you want to do it. You might want to forward a request to a system that automatically parses through all the databases and deletes the data, or it could be a manual process. Again, up to you how you want to do that sort of thing. Employees have got to get trained and retrained to understand what you can and cannot do with consumer data or personal data. And last but not least, which is probably one of the biggest steps, if not the biggest one there, is you have to strengthen your data security, okay? So the security of the organization is paramount here because, again, when you take a look at the fines that were discussed before, the $2,500 and $7,500 fines are irrelevant again, I don't want to say irrelevant, but in comparison to the up to $750 per breach, not per breach, per person, per a California resident. So those numbers can be absolutely enormous. Now, CCPA does not specifically state you must do this with security, you must do that with security. They constantly say basically best security practices or baseline practices. So they on purpose do that. So they want to know, or at least they want to check that you're following sort of industry standards. Now, that could be things like, for those of you that are familiar with the frameworks and the different types of standards that exist, that could be what's called an ISO 27001. That could be a NIST cybersecurity framework. That could be a CIS top 20. So there are multiple types of compliance, but basically those are industry standards and industry best practices which they're expecting you to follow. So there's a lot that's involved here. I hope that answers your question, Eric.
Yes, it does. And I wanted to supplement that with a couple of quick comments with what you just said. In regards to a lot of these process procedures and best practice cybersecurity framework, one of the most important things that we advocate is, going through a process of actually looking at an assessment, implementing the process, but most important of all, with everything else that James has talked about in regards to training, process, and procedures, and everything else, is documentation. If it comes down to, at the end of it, in a compliance situation, at the end of it, we have to have, be it just dealing with the regulators or you get into a legal situation, we have to be able to produce the documentation that says that, okay, this is done and this is when it was done, and the process has to be gone through to do that. And one thing to keep in mind is, as part of this process, it is a continuous process. It's one of the very important things I'd like to point out is this is by no means something that you go through once and say, okay, we comply at this point in time, we're done. Because from a data mapping and tracking standpoint, you always have to be able to continuously do it. Take the removal request, for example. When it comes in, one of the requirements is that we have to be able to leave an audit trail of what was actually done going through. It doesn't do us any good to say, okay, we've done the removal once, but if it comes down to in the long term, it has to be trackable. The other part that I'm sure everybody is already aware is a very large part of CCPA that the other parts that you need to get involved with besides legal and talking to the lawyer is also reviewing your risk posture and taking a look into what are your risk threshold within your own organization. And the natural follow-up with that is what is above your risk threshold, you need to bring your insurance company into the conversation. And that's a very big piece of it that a lot of people don't think about until very far down the road in the process. That is one of the key part of looking at CCPA and going down the compliance road.
That's great. Thank you. Does anybody have any other questions before we continue to move on? Excellent.
There's just one, actually, there's one thing I wanted to mention as well. A question came up before concerning nonprofits, and I said that nonprofits basically are not covered under CCPA, which is a true statement. But there actually is, I was just thinking about it, there were a few amendments made that basically, I mean, in general, it does not apply, as I had said before. However, there are certain caveats, legal caveats, for example, if it's controlled by a for-profit entity, or it operates under a brand name that it shares with a for-profit entity. So things along those lines. There are a few caveats. Again, always speak with legal counsel, but I just wanted to put that out there that it's not 100%. There are certain caveats to that, what I had said earlier.
Great. It's one of the reasons why I like the B2B thinking about that, because a lot of B2B companies don't think that they'll have to comply, and we're finding that their attorneys are actually saying you do, and they're referring them to, to Consilien for some help. We do have one more question, James. How do I verify an identity? Oh boy. Okay. So if you actually take a look at CCPA, they actually have a diagram. It's basically an identity verification workflow, as they call it, for CCPA. Okay. It looks pretty daunting. Basically, what it comes down to this, so there are 4 areas. First of all, where's the requester coming from? What they're trying to do here
is determine, is this legitimately, let's say James Rothman, is this really James Rothman asking for his data? They don't want to give the data to the wrong person, to someone, for like fraudulent reasons. So they have to determine who the requester is. Then there's what's called a request channel. So basically, are they getting the information from the phone, in person, email, online, and so on and so forth? Then there's what's called a verification method. So there are tools, there are apps, there are different ways to determine the verification based on IP address. So based on this, like I said, it's mobile authentication, email authentication, knowledge-based authentication questions. So for example, if let's say they were in your, I don't know, your customer database, they might have had one of those backup questions that you could say, what's the name of your, what's your grandmother's, first name, things along those lines to check and verify. And then finally, a decision has to be made, either a pass or a fail. So it's pretty complicated, okay? So basically, firms have to plan for and manage several type of requesters, channels, verification methods. It's also based on the sensitivity of the data requested. So again, there are a multitude of companies out there that help with verification because, again, just because I say I'm James and I want all of James's information, they can't just send it out. There has to be some type of verification that's attached to that, that's included with that. Again, I hope that answers the question.
No, I thought that was terrific. Makes me think it's another way to get fished, actually.
Absolutely.
Mm-hmm.
And it's happening.
Yeah.
Absolutely.
I wanted to follow up with that comment that kind of brings back to mind a conversation we had with one of the legal partners that we work with in regards to the CCPA. And she had advice, and one of the suggestions she put out there is to advise all of our clients, potential clients, to say, when we go down the CCPA route, it's best to engage the legal side of it as early as possible, and then have the legal side work in conjunction with both your risk, meaning your insurance side, as well as your cybersecurity side team, and have your legal team provide the guidance. And it was an interesting viewpoint is that if you do take that advisement from your legal team to take certain direction, for example, to do the assessment, to do a certain amount of protection of information, if that directive comes from your lawyer, a lot of it could become so to speak, privileged information. And it becomes a big strategic item on how you strategize and protecting yourself. So that's one of the things I want to throw out there is that if you go down this process, get all your key people together, assemble your team, and work in conjunction as a team instead of working individual silo. Hey, you have the legal side work on this by themselves, have your insurance side work on this side, and have your cyber side work on this side. This really should be a collaborative effort on the team that you're going to helping you guys move towards CCPA compliance.
Right. And we do have resources. As Eric said, we have legal partners for CCPA and privacy. If you need that, you can reach out to me or Nancy, and we would be happy to provide you with some of those resources. I think we're going to just continue to move on in the interest of time. If you have more questions, you can always, again, send them to myself or Nancy, and we'll be happy to get you the correct answer. All right. So how can Concilium help? So again, we provide managed cybersecurity services. And what that means is we can help you assess your environment, protect your environment, and then help you with the evolution of your environment, help you manage the complex cybersecurity landscape. So again, going back to what Eric and James were talking about, the ability to find out what your gaps are, what is your risk tolerance, having an assessment done, protecting your data, protecting the company. We can help with that. And then also with the evolution, that training that James and Eric were talking about, the continual need to train your people. We can also help you with that, with security awareness training. And of course, with consulting, with Chief Information Security Officer, Chief Information Officer, and Project Management. We can help you with all levels of consulting with your security and infrastructure needs. So what are your next steps? We do have an IC24 assessment package, and this is your strategic roadmap towards CCPA compliance. There are 3 aspects to that. We do a detailed security assessment that includes some of the questions for CCPA, a vulnerability scan to determine what your network looks like, how secure you are. We're going to help you see those gaps, and then we're going to put together a report to give you a roadmap. It's very difficult to be compliant if you don't have visibility. So this assessment package will help you get the visibility that you need so that you can move forward with CCPA. Again, you can contact me directly, Krista@Consilien.com, or if you work with Nancy, please reach out to Nancy as well. So that is it for our webinar and Q&A. Again, thank you so much for taking the time out. And I will be sending this along with the recording to you so you can share it with the people in your organization. All right. Thank you so much, everyone.
Thanks, everyone. Thank you.